I'm going to talk about rescission at common law and in equity, which is actually a much more interesting topic than appears from the title. The starting point is that when, under the Judicature Acts of 1873 and 1875, the courts of the common law and the courts of chancery were brought together under one regime. Since then, we have got so used to the idea of having one united system that the old distinctions between equitable and common law rules don't really matter anymore, except in a very few areas, and rescission is one of those. But before we get to the differences between rescission in common law and in equity, we need to deal with a bit of language. What do we mean by rescission? Because even as experienced commercial lawyers, we use the term rescission to refer to a number of different circumstances. And there are three which we need to identify for present purposes. The first is termination of a voidable contract by a party. So one way in which we refer to rescission is to describe that termination by a party by making an unequivocal communication to the contractual counterparty of an intention to bring the contract to an end. Now, a voidable contract is one which has been entered into as the result of some established voidable qualifying grounds such as misrepresentation, mistake, or duress. The second type of way in which we sometimes refer to rescission is in fact not rescission at all, and it's termination for breach. And it's very important to distinguish between termination for breach and rescission. They both involve the act of an innocent party to the contract, but they are conceptually distinct, and there are important and different consequences that apply when the contract is terminated. So when we talk about party rescission of a voidable contract, the contract is terminated for all purposes, and the court seeks to put the parties back in the position that they were in prior to the contract being entered into. That's different from termination for breach, usually fundamental breach, where the guilty party, the breaching party's primary obligations under the contract are substituted for a different obligation, which is an obligation to pay damages for the loss which has been suffered by the innocent party as a result of the breach. And the way in which that distinction is often thought about is that rescission operates so as to terminate the contract and take you back to the beginning, and termination for breach operates to terminate the contract and then looks to the future, suspending contractual obligations and replacing them with an obligation to pay damages. But the important point for today's purposes is that terminating a contract for fundamental breach isn't actually rescission properly so called at all, and we're not going to look at it anymore. The third way in which we talk about rescission is when the court does it. So when a court finds that a contract is voidable under a qualifying ground, and as part of the relief it awards at the end of a trial, it sets that contract aside, that is rescission properly so called, but it's different from the rescission that occurs when a party terminates for under a voidable contract. And for the purposes of today, it's useful to characterize those two different types of rescission as self-help rescission, that's when a party terminates a voidable contract, and court-ordered rescission, which is when the court sets the contract aside at the end of a trial. Really what this talk about is identifying the difference between those two circumstances and the important but often misunderstood set of rules which distinguish them. And in particular, I want to focus on the fact that self-help rescission is available in a far more limited set of circumstances than court-ordered rescission. And the key to understanding the difference between self-help rescission and court-ordered rescission is to understand the different approaches that the courts took pre-1875 to rescission, depending on whether you were in the common law courts or the courts of equity. There are grounds for rescission available under common law, and there are grounds for rescission which are available in equity. Confusingly, there are some grounds which are available in common law and in equity. In common law, a contract may be rescinded if it's been procured by fraud, which includes bribery, duress, and there's a separate category of insurance contracts, which I'm not going to deal with today, for which common law rescission is available. But note the very limited grounds upon which a contract may be rescinded at common law. By contrast, in equity, the grounds available for rescission are much wider. You'll see there that fraud and duress are both not just common law grounds, but equitable grounds as well. And as we'll see, that's caused no end of confusion amongst the case law. But as well as those two grounds, non-fraudulent misreps, undue influence, breach of fiduciary duty, unilateral but not common mistake. Common mistake isn't in fact a voidable factor at all. If a contract is entered into as a result of a common mistake, it's not voidable but void. But unilateral mistake is a ground for rescission, and unconscionable bargain. The view that's taken most commonly amongst the textbooks and the authorities is that self-help rescission, that is, rescission by a party, is only available under a common law ground for rescission. But that is in itself probably a controversial statement. There was a line of authority which concluded with the case of Horsler and Zorro in the High Court in 1975, which held that self-help rescission was available not just for common law grounds, but also for equitable grounds. Since 1975, the case law has been pretty clear, and certainly the modern textbooks are pretty clear, that equitable rescission has to be ordered by the court, so is not amenable to the self-help rescission remedy. That was certainly the finding of Mr. Justice Foxton at first instance in the SK Shipping Europe and Capital VLCC 3 Corp case. But in the Court of Appeal, although it didn't matter for the purposes of the Court of Appeal's decision, the Court of Appeal observed, Lord Justice Males at paragraph 89, that in that case, which involved a negligent misrepresentation, so it wasn't a case of fraud or duress, Lord Justice Males described the idea that negligent misrepresentation could only result in rescission by order of the court as, open quotes, highly controversial, close quotes. I mentioned the difficulty that has been caused by the fact that fraud and duress are available as grounds for rescission on both common law and equity. Equitable rescission for fraud has caused particular difficulty, and in the case of JGE USA Investments Limited and HMRC in the Court of Appeal in 2021, Lord Justice Henderson described the authorities on the availability of self-help or court-ordered rescission in a case of fraud as in such a state of disarray that only the Supreme Court can reconcile them. Assuming for present purposes that the modern line of authority culminating in Foxton J's judgment in SK Shipping is right, there are several important consequences to the fact that self-help rescission is only available under common law grounds. The first and probably the most important is, what it means is that when the innocent party rescinds a contract on a common law ground, i.e. fraud or duress, the contract is immediately rescinded. And the role of the court in that case is merely to adjudicate, if indeed there is a dispute, on whether the qualifying ground is made out and whether the act of rescission was sufficiently unequivocal. If the court determines those issues in favour of the terminating party, i.e. that self-help rescission was effective, that's its role complete. The court has no discretion and simply does not go on to make orders consequential upon the rescission. And I've set out in the handout a useful extract from a decision of Lord Justice Roach in the 1995 case of TSB and Camfield, which makes that point clear. What he said was, in such a case, the court is not being asked to grant equitable relief, nor is it, in my view, granting equitable relief to which terms may be attached. So that's the first and most important difference. Secondly, it means that if a party purports to terminate a contract by an act of self-help rescission in relation to a contract which may only be rescinded under equitable grounds, so if someone says, I'm rescinding this contract because it's been procured by a non-fraudulent representation, that rescission is of no effect whatsoever. Thirdly, only the court can rescind contracts on equitable grounds, and like all equitable remedies, rescission is at the discretion of the court. So unlike self-help rescission, where once you as the party pull the trigger, the contract comes to an end providing you've done it properly, under an equitable ground, even if you establish your right to rescind, it doesn't follow that the court will rescind your contract. Equitable rescission is an equitable remedy, and it remains at the discretion of the court. That's not to say it's a free-for-all. The court will act upon well-established principles when deciding whether to grant rescission of a contract under an equitable ground, and one familiar principle is that rescission will not be ordered where it would be impossible to return the parties to the positions that they occupied prior to entry into the contract. But the important point is that consideration doesn't arise under self-help rescission for fraud or duress. The court simply doesn't have a discretion to exercise. So what should immediately be clear to everyone is that common law rescission, self-help rescission, is a much more powerful tool available to an innocent party than equitable rescission. And in particular, with the two grounds on which there's overlap, so fraud and duress, where one can choose between common law rescission or equitable rescission, it remains completely unclear to me why anyone would take a deliberate decision to rescind under the equitable ground rather than the common law ground. There are other differences between self-help rescission under common law and court-ordered rescission under equitable grounds. Timing. So as I've already alluded to, when rescinding under a common law ground, the contract comes to an end once the unequivocal intention to not be bound by the contract is communicated to the other side. Under the equitable ground, the contract will continue until the court sets it aside. And given that litigation nowadays can take 12, 18, even 24 months to come to court for judgment, that is a material difference. Recovery of monies paid is treated differently, because when a contract's rescinded under a common law ground, the monies paid under that contract become repayable as a debt. Under equitable rescission, the innocent party only has an equitable entitlement to be repaid an equivalent sum to that which had been transferred under the voidable contract. Similarly, recovery of property is treated differently. Under a common law ground, when a contract's rescinded, the innocent party automatically, without any role of the court at all, regains the legal title to property which has been transferred under the voidable contract. Under the equitable ground, equitable title will pass as soon as the party has elected to rescind the contract, but the legal title won't revert to the innocent party until the court makes an order to that effect, if indeed the court does make an order to that effect, which remains in its discretion. Because self-help rescission is such a powerful tool, it's important to get it right. And it's important then to understand how one successfully invokes self-help rescission. And the general rule is that the innocent party must communicate to their contractual counterparty an unequivocal intention to disaffirm the contract. That sounds like quite a formal way to do things, but it's not. It can be done in a relatively informal way. The case law says it can be done by words or conduct. It's obviously safer to put it in writing. Self-help rescission can be invoked by a statement of case in court proceedings. And because self-help rescission doesn't require any order of the court, the communication of that unequivocal intention to disaffirm can be made in a defence or even in a reply. Now, these distinctions between common law and equitable grounds for rescission, the fact that self-help rescission is only available for common law grounds, and the limited role of the court in cases of self-help rescission are, at least in my experience, not well-known principles. We all use the word rescission very often, but we don't always use it accurately. And these principles, if you don't know about them, are apt to cause confusion. And I'm currently representing a party whose case was struck out when a judge held that their plea that a declaration of trust had been rescinded for fraud ought to have been pleaded in their particulars of claim, rather than in their reply. The judge proceeded on the basis that there had to be a claim for rescission which the court either upheld or rejected before the court was seized of the matter. The judge didn't appreciate the difference between self-help rescission and court-ordered rescission, and the fact that we were claiming in that case rescission for fraud, which is a common law ground and requires no intervention from the court. We await with interest a decision on our application for permission to appeal. One final point to touch on is affirmation. And the reason that affirmation is important is because affirmation results in a loss of the right to rescind. It involves the loss of the right to self-help rescission, and it also involves the loss of the right to seek rescission as equitable relief from the court. And the right to rescind will be lost if the innocent party, once free of the factor which renders the contract voidable, manifests their intention to affirm the contract. And those words, once free of the factor which renders the contract voidable, are really important. To take an example, in a case of a misrepresentation, in order to affirm, a party would have to know that they had been the victim of a misrepresentation. So they need to know what the true facts were. Whilst they remain under the misapprehension of the misrepresentation, they will not be found to have affirmed whatever they do. And the theory which lies behind affirmation is the right of election. And it's a long-standing rule in the principles of the right to elect that in order to affirm, an innocent party must be aware of their right to elect, i.e. that they've got a choice whether to rescind or affirm. So it's not until they are free of the factor which caused the contract to be voidable in the first place, and not until they know that they have a choice whether to rescind or affirm, that a party will be in a position to affirm at all. Once those circumstances do apply and the party can affirm, they affirm only by express words or unequivocal acts. So the bar is set pretty high for affirmation, both as to when a party can affirm and as to how they can affirm. The law sets its face really against affirmation in circumstances where rescission would otherwise be available. So in conclusion, the distinction between rescission on common law and equitable grounds, which isn't one that has been consistently maintained in the authorities, has led to no little confusion. The principles that I've discussed today are only a small part of the law of rescission, and they can hardly be described as settled. However, the takeaway from today is hopefully an understanding that the regimes which apply to common law and equitable rescission are significantly different, and they can form a trap for the unwary.